Well, I got my stitches out yesterday. I had 14 to this spot right here. Had another one down there, and some on my finger. It didn't hurt as much pulling them out as it did when they were putting them in, particularly on the forehead. And anyway, before I fell down, I started to talk about the need for cultural change in the courthouse. And I suppose I could understand what happened easier than most people because I was there when it happened the first time. When I got out of law school, crime had to be a matter of specific intent. You had to specifically intend to hurt somebody, to injure him, to rob him, or whatever. Then, as society got a little more and more uptight, they changed that in about 1970, 71, to where specific intent was no longer a prerequisite for criminal behavior. All you had to do was have a general intent. So you didn't have to specifically mean to do harm to an individual. If it occurred resulting in harm, then you were guilty of a crime. Well, this had significant consequences in our society and has driven the conviction rate astronomically high since then. And also you have got a situation where the perception of the public is that anytime there's a hurt, there has to be a crime and somebody should have to be punished for it. It almost goes back to ancient Druidism, where when a young man would fall out of a tree, they would punish the tree because it hurt the young man. So they chop it down. Now, Nixon got in right about the time that this change was going on, and he was a big proponent of law and order. And law and order meant let's crack down. Let's not put up and tolerate deviance of any sort. And mainly it was concerned with protests against the Vietnam War. They were viewed as harmful, communist inspired, all kinds of things such as that. But the general consensus was, since World War II produced all these patriots in the United States, that anyone who would object to being drafted into the war in Vietnam had to have been funded or inspired by communists, and we had to stop the communists at Vietnam or else stop them at the gates of San Francisco. At the same time, other things were going on. There was black agitation. Martin Luther King was leading his group into prominence. And the press was treating everything in a racial matter, when in fact it should have been viewed as an economic matter. And when King started talking about economics, about disparity in income, status, etc., all of a sudden he got whacked. As long as he was talking about black and white, it didn't seem to matter that much. Anyway, they specialized the prosecutors in the Nixon administration. So no longer were we the equivalent of barristers in England, where we prosecuted and defended both. We became specialized, and the prosecutors became specialized and became focused and narrowed on certain crimes. And the conviction became the end in itself. So when you have these specialized prosecutors and specialized police, you create a culture that is different from the one that existed before. I remember when I first started practicing, I used to go out and have drinks with prosecutors, police officers, things like that. I haven't been to a police officer's retirement party in probably 20 to 25 years. were no longer viewed as members of the same club, were the enemy. Defense attorneys and prosecutors are supposed to be natural-born enemies. We no longer look after the interest of society, but only the prosecutors are allowed to do that. Defense attorneys are obstructionists, so if we pitch an objection to some policy, we're obstructing. And that's got into the culture. For instance, right to bail has been a right since Magna Carta, and the propaganda now is the courts slap the people on the wrist, the cops go out and arrest somebody, and right away they're turned loose, which is called bail. And these officers took an oath to the Constitution, and then they sit around bitching about it. Their job isn't to police everything and protect everybody from any possible threat. Their job is to investigate and to keep the peace. And once you have solved the problem with keeping the peace, you're no longer needed. So just because you work hard to arrest somebody that smoked a marijuana cigarette doesn't mean you have to keep him locked up the rest of his life in order to protect other people from having inhaled the marijuana smoke. But that's the logic of the police state now. So what happens then is it evolves into them and us situation. So the police are us, and everyone else is a them. Everybody's a suspect. Everybody's a potential criminal, and they're viewed as such. Now what happens is the prosecutors are young men right out of school generally, and that's where they start. They start prosecuting, working with police directly. And the police are always belly aching about this, that, or the other. The judge threw that case out on a technicality. Police tend to view the Constitution as a technicality rather than the supreme law of the land. And they're always belly aching about this, that, or the other. They take any acquittal or dismissal of a case as a personal insult to their integrity and their competency, which shouldn't be the case. But they do. Now imagine a young prosecutor going through this for several years, only hearing the police bitch about this, that, or the other. Unfortunately, what happened in most states, in order to save money, they decided that the prosecutors should come from state employees so they could save on the pension plans. So about 90% of the judges nowadays are former prosecutors. And they go on the bench with this particular bias. They've been listening to their police clientele for several years and see everything through that point of view, and are reluctant to look at other alternatives. So I'm going to give you an example of a case I had recently, where right before I retired, it was a drunk driving case. And drunk driving cases are treated very seriously for various reasons. There's a political agenda going on. And so they're a high priority case. Now it used to be you had to prove somebody was guilty beyond a reasonable doubt, and had to show he was guilty, had to show that he was drunk, that he was behaving due to influence of alcohol. Well, that got hard to prove. And one of the reasons it got hard to prove is that police tend to exaggerate and bellyache a lot, as I said. So at first, when they were arresting people for drunk driving, they would have to get permission to take blood tests, etc. And of course, any logical surviving defendant would refuse. So the legislators got together and said, well, if you get a license in the state of Colorado, you are implicitly consenting to a blood test to be able to drive. So if we pull you over on suspicion of being under the influence of alcohol or something, you've got to take a blood test if we insist. Well, that got a whole bunch of different rules, regulations going. and clouded the issue. The next thing is they had too many trials because there wasn't any clear definition of whether somebody was intoxicated to the point that it interfered with his ability to drive a motor vehicle. So they invented another crime, and that was driving while impaired. And they instructed the jury, if you find the defendant was impaired in any degree by alcohol, you can find him guilty of driving while impaired. So that made it virtually impossible for anyone to be acquitted of a drunk driving charge or alcohol-related offense. Now, the other thing is you had all this stuff with the National Transportation Safety Board and all this money going into drunk driving enforcement, and it became a high priority thing. And the young prosecutors were schooled in this and indoctrinated into this ideology. And it became such that your job wasn't to determine guilt or innocence as a judge, but it was to shore up the public relations aspect of the danger of drunk driving. So you had propaganda campaigns by district attorneys and by police departments, etc., about turning up the heat and drunk driving. You had groups like Mothers Against Drunk Driving formed, and it became more and more likely for somebody to get convicted of drunk driving. Well, pretty soon the idea of protecting the public overrode the principle of protecting the law. And it was very important that somebody arrested by a policeman for drunk driving be convicted of drunk driving. Otherwise, the policeman felt that he was slapped in the face and insulted, etc. So we get this one guy, a client of mine, maybe 10 years younger than I, and he got in a motor vehicle wreck, and he was disoriented on the curb. Police came and they suspected him of drunk driving. Well, he had all kinds of other medical problems, but that's irrelevant right now. So let's take a look here at the case, what the case file says. It says, it was the adult arrest of Mr. Safron. It was his second DUI in 5 years in careless driving, causing bodily injury. He did not stop at a stop sign on 9th and University and hit another vehicle, causing injury. So they screened him for drug. They transported him to community hospital, where he was medically cleared. He was then transported to jail and lodged there for substance abuse charges and further investigation. Now that's what the police report said. Here's what the traffic accident report said. Essentially the same thing. It was running a stop sign, and he refused, it said, to have a blood test. We'll get back to that later. So we have a police report here that said this report documents the arrest, etc. On the scene, defendant showed indicia of being under the influence of alcohol and or drugs. He was transported to Boulder Community Hospital, where he was medically cleared. Well, where's the drugs? Where's the alcohol? He's just a suspect right now. And now we have a report of the attending physician. And here's the one from the ambulance driver. I drove on west on University and observed that what appeared to be a fresh vehicle accident. Several bystanders were waving me toward the lane and into the bike lane along the north side of the University Boulevard. Several bystanders were there, and he saw the car that he described and pulled into it to where it was and looked at the people that were there and saw somebody that had been injured. So we get a DUI arrest for him. It said his leg stand was okay, his balance was okay. And everything else was cleared on the checklist. Now it gets interesting. We have a toxicology report from a state laboratory. It says, I'm an expert in forensic toxicology, etc., been qualified over 30 times as an expert witness. I reviewed the records and lab reports provided on Mr. Safron. It is my understanding he was taken to Boulder Hospital and a urine sample was collected and a drug screen performed at that time. The toxicology results were all negative. The urine drug screen was for amphetamines, cocaine, opiates, psychedelic, and cannabinoids. All of them were negative. Given the test result, it is not possible for a reasonable degree of certainty or scientific certainty to conclude the defendant was driving either impaired or under the influence of alcohol or drugs. My opinion is based on current scientific research, accepted forensic toxicology, and information I have regarding the case furnished by the police. On the back of it has all the tests that were performed. Then we have another one from an MD. He has no idea why he was in an altered mental state while driving. The most I conclude is Mr. Safron was altered for unknown reason. The drug screen was negative, and the emergency room record does not provide definitive evidence of any cause of this condition. I provided psychiatric treatment for Mr. Safron and have never known him to have a mental state which he described in these reports. So what is it? We don't know. We know it's not drunk driving or driving under the influence of either drugs or alcohol, but the prosecutor has insisted on going to trial. So next we have a statement where the person driving the other car was hit. The other car didn't stop at all, and this is all within Boulder, Colorado. Now, while they went through his car and his glove compartment, they did find that he had a medical marijuana card. a medical marijuana card in Colorado at that time. Medical marijuana was legal, but the police, of course, didn't quite believe that it should be legal, and they were making up their own rules at the time. So here we got a narrative by a policeman. It said that when he arrived on the scene, Mr. Safron had his cell phone out, and he was sitting on the sidewalk. I asked him if he was all right, and various questions. They talked to the other person. I contacted Safron. He maintained he was not injured and did not need medical attention. His eyes appeared to be relatively clear, and he was able to maintain eye contact. I smelled what appeared to be an odd odor of alcoholic beverage, and he denied consuming any alcohol. Well, he also observed Mr. Safron to have a white powdery substance on his nose or around each nostril. He agreed to perform voluntary tests. He said he was not under a doctor's protocol at that time. He said he'd been in several accidents before and had head trauma occasionally. Then the Pride Mark ambulance showed up. He apparently passed many of his tests. When he did the walk and turn test, he lost his balance. So at that point, the officer handcuffed him, took him into custody. The ambulance driver showed up, asked about pain, etc. He had a black eye and a few things like that due to the airbag deployment. And they told him he was going to be transported to the hospital. Right after he got put in, he fell asleep, and the police called that narking off behavior. They did a blood chemistry, PBT, a BRAC, and observed a 0 reading for the blood alcohol. So he was put into custody, not knowing what was wrong, with some evidence that he hadn't been driving under the influence of alcohol or any chemicals, and not noting what his physical health position was, just that he was cleared from the hospital. So he went to jail. Now, I think that's dangerous. But we have one more report here. And it said he had taken some Sudafed. Now, when he was asleep, the cop said he'd narked off In my training and experience, I have observed a type of narking off behavior from people who recently consumed narcotics. And because he had done that, he assumed this was to be the case, as was his testimony. So they had a blood sample, they had all these samples, they tested them all, and none of them came back showing that he had anything. Now he seemed on the side, he seemed confused and wandered around. Said he was on his way home from a party. And it said during this conversation, his speech was slurred and inarticulate, and he was unsteady while standing or sitting. His eyes appeared to be relatively clear. However, he was not able to focus or maintain eye contact. Even though he said he felt dizzy, he took the test, the walking test. But he didn't indicate that he couldn't walk, so the cop assumed that he could. The ambulance driver also commented that he didn't see any signs of intoxication. So these are the reports. This is what I went to trial with. To me, there was no evidence of any drug use, drug abuse, or causation of any drug injection or ingestion for the ticket and for the charge. He did injure somebody, and we admitted that. Now they did give him a CAT scan. So the elements are you have to show somebody who's driving a car and that the driving behavior was erratic and it was caused by the consumption of an illegal drug or alcohol. None of the evidence showed that. And in fact, the toxicology showed just the opposite. But the policeman had their script about the bloodshot eyes and couldn't do his standing thing, and in their expert behavioral observations they thought narking off or passing out, which happens with head concussions by the way, was evidence of under the influence. So I waived a jury. The judge found the client guilty, and after the trial called me up to the bench and said, next time ask for a jury, because he wasn't about to offend the officers who would have construed a not guilty verdict as he calling them a liar or exaggerating. And that's what justice has evolved into nowadays. The conviction and the image of being tough on crime is more important than justice.